candidate.
The honourable member for Saint-Jean. Thank you, Mr. Speaker. First of all, I'd like to say that I'm very pleased to speak today to Bill C-15 to strengthen military justice. For many years, first of all, because I was elected member for Saint-Jean, and I never had an opportunity to speak about this. And this is a riding that has many ties with the whole universe of military.
The base, for example, with which all Canadian soldiers are familiar due to an important part of their basic training that takes place there. And also the Royal Military College of Saint-Jean, from which most of our senior military personnel graduated. And second, Saint-Jean is also an important center for the defense industry, including Rheinmetall, Cadex, Milquip, which contribute significantly to the regional economy. And finally, for historical reasons, since Mr. Speaker, you know that this year we commemorate the bicentennial of the War of 1812, and part of which took place in Local, in the riding. So in November 1812, a very small group of 200 Canadian regulars was able to hold off to more than 1,200 American soldiers, and eventually they were able to chase them back into the United States. So we are fortunate that the wooden blockhouse that is called the Local Mill, which protected the Canadian soldier, is still standing and is one of the most significant and interesting historical buildings in Canada. So I would encourage that if any of you here in this chamber, or indeed anybody listening, can be in the region this summer, this building is absolutely a must-see. Ensuite,
from a more personal perspective, I was in the military exactly 20 years ago, from 1992 to 93. I served in the French military under compulsory military service. I was a signaller in the signals company of the 4th Helicopter Regiment of the French Rapid Reaction Force, and I was directly confronted with the reality of military discipline and the consequences that one faces when we contravene the rules that are being debated today with C-15. So I'm quite privileged compared to most members who had an opportunity to speak to this bill, whether to debate it in this House or examine it in more depth in committee, since I, like my colleague from Abitibi-Témiscamingue, who also sits on the Defense Committee, have been in the field. So let's get back to C-15, which is a substantive bill, both quantitatively and qualitatively. It's 90 pages long, and it broaches complex legal concepts. Let me remind the House that this is the fourth time this bill has been presented. During the third attempt, it had been referred as C-41 before the members of the Standing Committee on National Defense, and they examined it during 8 hearings over 2 hours long, and the last one took place March 23, 2011. That's not so long ago. So what's important to note is that beyond the 16 hours of formal meetings, for which witnesses were questioned by members of the committee, there were in fact hundreds of hours of work and compromise to find reasonable solutions to real problems. And now today, this is actually being thrown in the trash. During the 40th Parliament, Bill C-41 included a section about the independence of military judges. In this Parliament, given the urgency of the matter, the government decided to extract those provisions and make it another bill, C-16, that we examined in committee last fall at the Defense Committee, and the NDP supported it throughout all stages of the bill. So C-15 is not an omnibus bill, similar to those tabled in 2011-12, but it does amend significant parts of the National Defense Act. So, first of all, Part 3 of the Act, which is, in fact, the Code of Military Discipline, and Part 4, regarding complaints against the military police, and there's an addition to the Act about the integration of the position of Provost Marshal of the Canadian Armed Forces. So first of all, I'd like to discuss one aspect that is extremely important in this bill, and that's the issue of discipline. In his excellent speech of March 29th, the member for St. John's East broached the issue of discipline and explained how this is one of the pillars of any military organizations because the lives of soldiers depend on discipline. Among others, he quoted retired Colonel Michel Drapeau, who said, "Discipline is essential for effectiveness. It allows commanders to control the use of violence in order to make sure that we are exercising the right type of force in the appropriate circumstances, as well as the timeliness and place that are appropriate. From a personal standpoint, discipline means that soldiers can execute orders even if their survival instinct and fear dictate otherwise."
As a member of as a non-commissioned officer, rather, I myself was trained to understand that military justice is different from civilian justice because it has to respond to two additional requirements, discipline and rapidness. So I can say that when you wear a uniform, you're subject to pressure that doesn't exist in the civilian world, and were it not for the existence of orders that you must obey, obviously to the extent to which these are not illegal orders. And I can remember when I was taking my military training that I was made aware of the particular problem of illegal orders, but nevertheless, the experience shows that when an individual is subject to this kind of specific pressure, well, that individual is led to commit acts that they would have never committed in civilian life. I would also like to talk a little bit about the procedural aspect of the issue that we're dealing with today. Our role as parliamentarians is to study in detail bills, no matter how complex they may be, but our responsibility as elected officials is also to summarize our work and to explain to Canadians how their government is behaving in a specific instance. And when we give those explanations, Canadians don't understand that their government, and it's the same government that is artificially shaping it out or carving itself out a reputation as a good manager of money, hard-earned by Canadians, and is throwing out hours of work that was made on 3 occasions to improve the bill. Instead of using as a starting point the latest or the most recent previous version of the bill, the government is using its position of strength and is starting from zero. And Canadians can understand this. And the saddest thing about this, Mr. Speaker, is that this previous version of C-41 was the result of discussion, reflection, and consensus. And Conservatives can't understand the word consensus, and that's really sad. I would like to start by talking about points that we in the NDP believe are in the right direction, and then I will talk about where there are issues of discord. We agree with all the measures that seek to ensure better uniformization between the system of military justice and civilian justice. And there is a typical example, and that is the issue of the jurisdiction of the court. In fact, there are some offenses or crimes that are committed within a military base. And in that case, it is a military tribunal that is seized with the issue when it is not a crime that concerns the operational context of a soldier's work. So it should really go to a civilian court so that the accused can benefit from all the civil protections that are set out under the Charter of Rights and Freedoms. So what are the points that we think the government could improve in these reforms? There are mainly three of them. There's the summary trial system, the Canadian Forces Grievance Committee, and the Canadian Military Complaints Commission. So let's talk about the summary trial. This is extremely important because, as we've heard previously in various speeches, 90% of military offenses go through a summary trial process. The main concern raised by my colleagues from St. John East during the committee work was the fact that the procedures followed during a summary trial, unlike what happens under civilian justice, do not sufficiently protect the rights of the accused, and he had tabled amendments in this regard because, as he said, one of the main or general principles of natural justice is set out in procedural equality, which is, among other things, the right to be able to be judged by someone without bias. And you would agree that in a summary trial, when you are tried by a superior, this is not someone who is has no bias. Another case that is extremely interesting and that we should look at is the case of countries who have the common law as their law, but who have amended their legislation to ensure a better procedural equity. In fact, the European Court of Justice has estimated that military summary trials violate the European Convention on Human Rights. This is the case for the United Kingdom, which had to amend its legislation, in fact. So, as we said previously, if countries who are members of the Commonwealth, like Ireland, Australia, New Zealand, have been able to make those legislative amendments, why then cannot Canada do the same? And to conclude on this point, I would say that we cannot deal with the issue of summary trials without looking at criminal records, and I'd like to take a few minutes to talk about this now. One of our main concerns is that soldiers are not treated less equitably than civilians, and that this treatment, well, we don't want our soldiers to be treated less equitably than civilians, and this should not be unfair to them when they return to civilian life, because, of course, after a certain amount of time, soldiers go back to civilian life, and what concerns us is the direct tie between the summary trial in the military world and the risk of having a criminal record under the Criminal Records Act in the civilian world. So we know, and this has already been said, that a criminal record plays an increasingly important role in our society, and not only when it comes to crossing the border, which is an obvious case, but also when it comes to finding a job. So it's a good thing in and of itself, but on the condition that the processes that led to the registration of a criminal record were and have been as rigorous and as fair in a military context as a comparable process would be on the civilian side. And one of the solutions, or possible solutions to this issue, could have been to say that anyone who has been tried under a military summary trial cannot have a criminal record in the civilian situation. Unfortunately, this is a solution that wasn't retained. We can take a few examples. For example, let's say you are under the influence of drugs and you have demonstrated conduct that is a discredit to Her Majesty's service, and this is a punishable offense in the military world, whereas in the civilian world it's not even an offense. Then we can take another case of faking being sick, for example. And in operational circumstances, special operational circumstances, this can lead to life in prison, because this could endanger the lives of other soldiers. And in the civilian world, this kind of offense would not be punishable in a criminal court. So this is one of the examples that could have consequences with regard to creating a criminal record in the civilian life when the action occurred in the military world. The second point concerns improving the bill, and this is under the Canadian Forces Grievance Committee. Currently, the committee is exclusively made up of members, retired members of the Canadian Forces, and we would like more civilians to sit on the committee. And in fact, initially we were favorable to the idea of the committee being exclusively made up of civilians, and my colleague from St. John's East had tabled an amendment to that effect. During discussions, the committee had, in the previous legislature, or Parliament rather, had found a compromise to ensure that at least 60% of the committee members were members of the Canadian Forces. So the amendment had been adopted in committee. Why did the Conservatives then withdraw that from C-15? Another aspect that was debated in detail during meetings of the National Defense Committee is the fact of having the Chief of Defense Staff be the one to make decisions concerning financial issues. In fact, Justice Lammer had requested that this be changed for over a decade, and this was regularly raised by the Canadian Forces Ombudsman as well as by the chair of the Canadian Forces Grievance Committee. So in order to clarify what I mean, I'll try to explain. We think it's unjust that the Chief of the Defense Staff doesn't have the power to make a decision, but simply to issue a notice that an applicant who is subject to the notice would have to use to make payments through national defense. And then there is also the Canadian Forces Complaints Commission. The Military Police Complaints Commission should really become an oversight organization. I'd just like to give a little bit of oversight of historical review. This was created by the Canadian Parliament in the wake of Somalia because we wanted to ensure greater control. So what we think is that this reform is not ambitious enough and doesn't go far enough. Since I have a little bit of time left, I would like to come back to the issue that was, or the question that was asked by my colleague from Edmonton Centre. And he had asked the member for Abitibi-Témiscamingue a question to ask how summary trials were not constitutional, and I simply want to read a decision handed down by the Supreme Court of Canada, which confirmed in the Wigglesworth case, Regina contra versus Wigglesworth, and I quote the Supreme Court, if a person is subject to criminal consequences such as imprisonment, they must have the best protections provided by procedural law. And this is what the Supreme Court decision was. I don't know if my colleague opposite from Edmonton Centre will have the opportunity to talk about that. But in fact, that is the reason for which we have taken this position with regard to summary trials. In conclusion, Mr. Speaker, I would like to say that for all the reasons that I've mentioned in my speech, the NDP will not be supporting C-15 in second reading, not because we are opposed to the majority of the provisions set out in the bill, but rather because we cannot support the government's action, which is to deliberately ignore recommendations that were made by parliamentarians during a previous parliament, and what we are asking the government quite simply to do is to amend its bill in order to take into consideration the results, as I have said, of hundreds of hours of work that were accomplished by various committees during the previous parliaments, or standing, particularly by the Standing Committee on National Defence. Thank you, Mr. Speaker.
Questions and comments? Questions and commentaires?
Questions and comments?
For Winnipeg North.
Thank you, Mr. Speaker. I did want to just put a few thoughts and pose it in the form of a question on the record. Having served in the Canadian Forces for a number of years, I understand and I appreciate the differences between civilian life and military life, and many members of the forces see it as that. There is a great dependency in terms of discipline within the military and to follow orders. And there is this obligation, unlike the civil outside of the military, where if you don't feel like going into work today, you can leave. You don't have to. You might not have a job at the end of the day. You can feel free to call in sick without any consequence. If you don't like what it is your boss is saying to you, you're free to quit, or even to a certain degree, possibly even backtalk. But we need to recognize in the military you don't have those types of options, and there needs to be a consequence in order to have an effective force. That discipline factor and following orders is absolutely critical for the Canadian Forces' sheer existence. And my question is that in principle, in looking at this legislation, yes, there is a need for it to change and to be modified to the degree in which it would probably be more effective. But my question to the member is, in principle, why would the NDP prevent the legislation from passing? As I say, I acknowledge that there is a need to make some changes to it, and amendments would most certainly be welcome. But why would you oppose the bill in principle in its passage?
The Honourable Member for Saint-Jean. Thank you, Mr. Speaker. I want to thank my colleague for that question. In fact, he is asking a very interesting question. He's taking the example of simulation, that is, there must be consequences. And I said in the beginning, discipline is one of the pillars of any military organization, because once again we're talking about the life of other soldiers who depend on discipline and the application of discipline. We're not denying that, and no one is denying the importance of discipline. No one is denying either the fact that, as he mentioned, somebody who is guilty of this type of offense and who would commit that offense, we're not saying that there should be no consequences for such actions. However, what we're saying is that when a soldier is accused, for example, in the case that we're talking about here, what we're saying is that the process used in the military circles must not be less fair than the same process that would have led to the registration under the Criminal Records Act in civilian circles. So we're not talking about decriminalizing the action in and of itself, because what we said was that this action can have consequences on other soldiers, and other soldiers might lose their lives because one soldier did not respect his or her commitment to stand guard. And the best example is standing guard, a soldier, in fact, who falls asleep or who pretends to be sleeping in order to avoid standing guard means that perhaps their colleagues might be killed. And we're not denying that. What we're saying, however, is that it's a question of process once the act, independent of the consequences, but once the act has been committed and the soldier has been arrested, the process must be as fair as it would be in the civilian world.
Questions and commentaires?
Questions and comments? The Honourable Member for Alfred Pelin. Thank you very much, Mr. Speaker, and I would like to thank my colleague for his excellent speech. He was very eloquent. It was extremely interesting, particularly by somebody who represents a riding where there are a number of military institutions, and someone as well who knows those military institutions from having served himself in Europe in the military. It's extremely interesting for a neophyte such as myself to learn more about how it works on the inside. My question will be quite simple, in fact, since I am interested by my colleagues' comments and I'd like to know a little bit more. What, in the amendments that could be proposed to this bill, what could improve this bill, in his opinion?
The Honourable Member for Saint-Jean. Thank you, Mr. Speaker, and I thank my colleague from Alfred Pellant. And as I mentioned, it's the fourth time that this bill is back on the order paper here. We've had time to discuss it. There were negotiations, discussions, except we have to see that during the last Parliament at the Defence Committee, the Conservatives did not have a majority. So, despite themselves, they had to accept a certain number of compromises. And so now today, they do have their majority. And I'm just speculating here, but I imagine that at the Defence Committee, they'll be in the majority as well. And I think that they still want to use that strength to ignore all of the negotiations that occurred in the last parliaments at the National Defence Committee. And to answer directly, what could we do? Well, we could pick up where we left off with Bill C-41 in the 40th Parliament and not take away the amendments that were negotiated and accepted by other members, whether they were Liberal, Bloc Québécois, or Conservative.
Questions and comments? Questions et commentaires? L'honorable député,
L'honorable député de Laval.
I want to thank my honourable colleague for his intervention tonight, and I think it is important in this House, when we hear so much rhetoric and blather from the other side about law and order and lock them down and punish them and pick them up by their bootstraps and all the other baloney we hear over there, that it's nice to hear from a member who actually knows what he's talking about, who actually has served in the military, who actually understands that an institution is just not some hollow vessel, but it's actually filled with people, with, in many senses, young people who are in a context. It's a bit of a rarefied context, and here they are. We're asking them to do things and to give of themselves in a way that's really extraordinary. And when they occasionally run afoul with the law, they're not given the kind of due process that anyone would expect. And I think many Canadians would be surprised that in this context and for certain infractions, those in the military aren't given due process. And I'm just wondering if my honourable colleague would want to comment on the general context in which this government is tabling this bill, stripping out some of the more reasonable amendments that had already been negotiated and leaving just the ones that follow their lock-em-down, law and order baloney.
The Honourable Member for Saint-Jean.
I would like to thank the member for Davenport for his question, and I really feel that this government and the Conservative Party is using their position that they have right now to have a completely different approach that they had under the previous legislation, and just because they have that majority, and they are claiming that they have a strong majority, but it is not true. 40% of the vote is not a strong majority. So they are, in my opinion, they are well, in the voters, well, if you take the perspective of the voters, this is not a strong majority, and this is not a majority at all. This is, well, this is just here that the majority that the members of the Conservative Party are using, and I would say abusing this position, and I'm very sad that they could have taken the previous amendments that have been negotiated under the previous legislation, and now they are scrapping all that and starting anew. And frankly, Canadian taxpayers don't understand why we have to pay so many people and to spend so many hours redoing things and doing things again.